Legal dictation. Exercise 85. Start. Mr. Jaspal Singh, learned senior counsel, appearing on behalf of the accused appellant, submitted that the order of conviction recorded by the trial court and confirmed by the High Court is not sustainable. Full stop. His main submission was to the effect that there was delay in filing the FIR on the part of the prosecution witness. Full stop. Had the story narrated by PW4 been correct, he would have immediately rushed to the police station to file the FIR, but he waited for around 20 days for filing the FIR, and the state delay has not been sufficiently explained by PW4. Full stop. The learned counsel also submitted that the pistol had been recovered from a public place, which was about half a kilometer away from a bridge, and the pistol belonged to PW9 and not to the accused. Full stop. There was sufficient evidence to show that the owner of the pistol was PW9 as established from the record, and therefore, the recovery of the pistol could not have been a ground for conviction of the accused. Full stop. Para. He further submitted that the parents of the deceased had not been examined by the prosecution, though, as per the version of PW4, he had talked to the parents of the deceased after the offence had been committed. Full stop. According to him, the FIR filed by PW4 contained a story, which was not correct. Full stop. There was no reason for PW4 to be afraid of anyone, and yet he did not lodge the FIR for a long period of about 20 days. Full stop. By not examining the parents of the deceased, there was suppression of material witnesses by the prosecution. Full stop. He further submitted that the statement made by the accused leading to the recovery of the pistol had not been produced in the evidence, and only the memo, which is in the nature of the secondary evidence, was produced. Had, therefore, recovery of pistol could not have been believed by the trial court. Full stop. According to him, even the memo, which revealed that in presence of witnesses the pistol was recovered, was not correct, because there was only one witness when the pistol was recovered. Full stop. According to him, at the time of making a recovery memo, there were policemen who were not examined, and there was no justifiable reason for not examining those policemen. Full stop. Para. On the other hand, the learned public prosecutor appearing for the state submitted that there was proper investigation, and upon appreciation of evidence, adduced before the trial court, the trial court rightly convicted the accused. Full stop. According to the learned counsel appearing for the state, the discrepancy, if any, with regard to identification of the pistol or the memo of recovery were so insignificant that there it would not lead to any serious consequences. Full stop. According to him, the prosecution had established the case against the accused and there was no reason to set aside the order of conviction. Full stop. He had replied to all the submissions made by the learned counsel appearing for the accused. Full stop. Para. We have heard the learned counsel at length and have also gone through the relevant evidence. Full stop. We have also carefully gone through the judgments cited by the learned counsel appearing for the accused, and we do find that the said judgments support the legal submissions made by him. Full stop. Upon perusal of the impugned judgment and judgment of the trial court along with evidence, we are of the view that the order of conviction passed by the trial court and confirmed by the high court is just a proper for the reasons set out thereafter. Full stop. In our opinion, the trial court has rightly appreciated the evidence and the High Court has also confirmed the order of conviction for justifiable reasons, duly incorporated in the judgment and order confirming the conviction. Full stop. So far as the delay in filing the FIR is concerned, there appears to be substance in what has been started by PW4. Full stop. Every human being would not react in the same manner which he sees commissions of an offense. Full stop. A person might be bold enough to catch the offender or he might run away and someone might never inform the police. Full stop.